and welcome to Environmental Laws, Thompson Hine's Environmental Law Podcast. In each episode, you'll hear from subject matter specialists at Thompson Hine and sometimes special guests on current events and hot-button issues in environmental law topics, covering land, air, water, and safety, hence the laws. I'm Heidi Friedman, a partner in Thompson Hine's Environmental and Product Liability Practice Groups and co-chair of our firm's ESG Collaborative. I was really excited to spend the last podcast talking to Joel Eagle about ESG, and today we get to drill into the next step, greenwashing. We're going to be discussing greenwashing today with my friend and colleague, Tanya Nesbitt. Hi, Tanya. Welcome.
Hi, Heidi. So excited to be here to talk about one of my favorite topics.
It is your favorite topic. You've been all over LinkedIn on this. I love reading your posts. So for the benefit of the audience, Tanya is an environmental partner who works from both our Atlanta and Washington, D.C. offices. Tanya has over a decade of litigation experience in private practice with the federal government. She is a nationally recognized litigator, and I think recently a law dragon. So she is fierce. Tanya is co-chair of the Public Land and Resource Committee of the Section of Environmental, Energy, and Resources of the ABA, a member of the Environmental Institute's Well Steering Committee, DC chapter, and she is a very significant part of our environmental group here. So with that, why don't we get started, Tanya, and tell us a little bit about what greenwashing is and where that term was derived, because I think that's an interesting story.
Sure. So I guess the interesting part is that there is no national or international consensus on what the term means. But we know that in the 1980s, an environmentalist by the name of J. Westerfield coined the term because he was pissed off that the hotel industry's Save the Towel movement was marketing itself as wanting to reduce environmental waste and water consumption. And I think he looked beyond that or past that and saw that they were more so interested in minimizing the cost of washing the towels. And so he felt that that was misleading and coined the term greenwashing. And so today, greenwashing generally is used in reference to an entity misrepresenting an environmental benefit claim of one of its products or misrepresenting its ESG credentials. And so some examples may be marketing your product as one that has no environmental impact or saying it has a positive environmental impact. And finding that there's either that's misleading or it contravenes data that would substantiate a claim like that.
Right. And those cases are just everywhere now. So as anticipated and expected, as the ESG disclosures and goals and targets are being put out there by companies, it seems like the litigation is going to follow. But as companies really prepare to, they want to meet their stakeholder demands, and they really want to set ESG goals, and I know they really want to meet them. How can companies mitigate their risk to avoid a greenwashing claim? There has to be some things I'm guessing they can do to make sure that they're not in federal or state court somewhere trying to litigate one of these claims.
Yeah, I think the important thing here to remember is that the risk exists for companies. We're seeing now an uptick in suits against individual company directors. The risk exists for regulated utilities and certainly governments as well. And so we have to think more broadly about mitigation. I tend to think of mitigation as both a defensive and offensive strategy. And so I think that, there is an inertia sometimes that sets in where companies may think, let's just sit on the sidelines and see how things shake out and not take action. And particularly in the greenwashing space, delaying or not taking action is going to potentially create liability. And this space is messy. It's shifting day to day. But the best approach is to jump in and get dirty and begin doing the things that are going to minimize risk. And so the first would be obviously to consult with legal counsel who can assist with the review of your advertising and marketing materials. And also don't forget your social media materials too, right? In this day and age, a lot of companies
Absolutely.
are doing that type of advertising and making these types of claims as part of that advertising. And so there is liability in those statements as well. Greenwashing mitigation also should be part of your regular auditing process and your due diligence that you would do for any other type of issue that the company would ordinarily face. And so there needs to be more integration in those types of compliance programs and compliance function. Also, companies should think about how their product is being sold and how it shows up to the consumer. If it's showing up different than it leaves the factory, you need to think about that and then think about liability and how it may be presented if it's in plastic or other items, for example. And the other is obviously to speak the truth and the whole truth, right? So making sure that there are appropriate disclosures for any of the claims that would give the consumer, I think, a fuller picture of, for example, what you may mean by zero waste to landfill, for example, giving any sort of disclaimers if there's a portion of that waste, for example, that is being incinerated, and thinking of it from that perspective, I think, is certainly helpful.
Right. The footnotes become more and more important, and especially in public filings on your website and all of that. So, what zero means to most people is zero. So if it's really not zero, we should just be clear about that. So
Exactly.
those are definitely the kind of things. And then I'm going to take you back to one of the things you said, which is integrate with the compliance functions, which I certainly think is critical. Talk a little bit about how data collection can really help mitigate the risk further in terms of, for every statement folks put out, that's certainly what we do with our ESG reviews as well, is make sure, my question is always, do you have data to back this up? Do you have data to back this up? Talk a little bit about how that can be collected and maintained to protect the company.
Certainly. So I think data plays a critical role both in your offensive and defensive strategy. And so offensively, you're going to use it to substantiate your claims and also determine where perhaps there isn't sufficient information to verify a claim and to sort of know where those gaps are. And there are instances where perhaps something was not advertised or marketed in the best way, but perhaps there is data, and that can be used to, ward off a lawsuit. We've seen plaintiffs sort of approach companies and ask for substantiation before engaging in litigation. And so that certainly, can be useful and useful again to inform the marketing and advertising of the claims. From a defensive strategy, obviously, data plays a huge role in terms of holding plaintiffs to a burden of proof and being able to perhaps exit a lawsuit at the summary judgment stage. And so having that information and working with third parties, experts if necessary, depending on sort of what data is necessary, are useful tools in a toolkit, and certainly not an area that I think a company should look to short circuit.
Absolutely. And now there's a whole new area, I think, of, with audits of that data and, having a third party review, which is sort of the next stage and the next level that I know a lot of our clients are working towards. So as we talked about a little bit, there are just a plethora of cases out there on greenwashing. I think every day there's a new opinion or some kind of new filing that makes you wonder how broad and deep these claims are going to go. Can you give an example of maybe a few cases of recent decisions, et cetera, and maybe if there are any that you're watching for precedents to give us a little bit of guidance of how to prevent these claims going forward?
Yeah, so we're seeing cases virtually in almost every industry. The utilities cases I thought were particularly interesting, I think, just given also kind of where the country is with a lot of federal money being allocated for transition to clean energy. And we're seeing obviously traditional fossil fuel companies trying to make that turn. And so there have been a number of cases against utilities for the advertising and marketing of their services through things like customer bills, right? And so I think that is an interesting area to watch. I think we're still waiting on some rulings in that sector. Seeing a lot of litigation on the circular economy and plastics. And I think that is it's not surprising given sort of where the climate change litigation is heading, and seeing sort of greenwashing being a subset of the climate change litigation. So a lot of litigation on sort of the recyclability of plastics and the advertising and marketing of products as being recyclable. We're also seeing cases make their own foodstuffs and market them, are also susceptible or have risk for greenwashing as they make environmental benefit claims for those products as well. And so there were a recent number of cases around dolphins and fishing regarding tuna and the marketing of statements in relation to tuna. We're also seeing a lot of state attorney generals take action, particularly against oil companies as well, for environmental benefit statements and claims made to consumers. So, and fashion, I can't leave out fashion. So a lot of litigation, again, in the context of sort of what does recycled plastic, plastics in the fast fashion industry, how can they be marketed or advertised, what's misleading, and can fast fashions really be sustainable? So it's a wide, I think, gamut of suits. I've been tracking, I think, a lot of the motions to dismiss on these lawsuits to see if we can get some more law to sort of inform where things are headed. We are seeing a lot of motions to dismiss in the 12b6 context, so defendants saying that plaintiffs essentially failed to state a claim. Courts generally are saying that statements that are aspirational in nature are not a violation of state Consumer Protection Act laws. And so if a company is saying in its statements it hopes to be carbon neutral by a specific date, that's not considered a specific claim. And so courts have dismissed complaints sort of alleging greenwashing in that context. We're also seeing courts dismiss suits where perhaps the statement or claim is not tied to a specific product. And so typically under the state Consumer Protection Act statute, you're going to have to allege some product or service was marketed in a deceptive or misleading fashion. And so you have to be able to tie that statement to a product. And oftentimes companies have not done that in their sustainability report or in their advertising or marketing. And so defendants, rightfully so, have filed motions to dismiss on that basis and have been successful. We're seeing also some interesting issues with regard to the amount in controversy requirement. A lot of corporate defendants particularly have sought to remove greenwashing cases filed in state court. They've tried to remove them to federal court. And so typically they've alleged that they would satisfy the federal amount in controversy requirement because, for example, the remediation of the wrong plaintiffs have alleged would require more than $75,000 to fix. And courts have relied on precedent that says that you cannot basically aggregate distinct and separate claims in order to satisfy the amount in controversy requirement. And so traditionally, we're seeing cases kicked back to the state court because that criteria it's impossible to meet in most instances. And particularly in cases where you may have a public interest group suing on behalf of plaintiffs in a general jurisdiction, having to meet that amount in controversy requirement for each plaintiff in the state of Maryland, for example, would be very difficult, if not impossible to meet. We're also seeing lots of courts cite the Green Guides, and I know we'll talk more about the FTC and the Green Guides later on, but we're seeing lots of courts cite them in their rulings, and reestablishing that the Green Guides are the sort of preeminent federal interpretive guidance on this issue. And so I think that's very instructive and will continue. And so that should be looked at very closely, obviously, by corporate defendants looking to mitigate against those claims. And we've seen
I
courts.
think before I think one thing I just want to emphasize before we talk a little bit further about the litigation is just, a lot of the decisions that you're talking about and things that have been like the claims that have been filed historically were consumer based, right? And a lot of them were food related or clothing related and all of that. One of the ones that I found most interesting was the Keurig case that, whether the pods were actually truly recyclable. And believe it or not, a court actually the class was certified there, and then the defendant settled, so we'll never know what would have happened there. But what I think is important to put an explanation point on is you're also talking about utilities, and you're talking about aerospace and auto and things that are not your typical consumer products, where these claims are going to be filed if they're not filed already, especially if the SEC rule comes out, and especially in a situation where they might not be filed by a consumer class action like we've seen in the past. They could be filed by shareholders or other stakeholders. So I thought that you were kind of giving such a lovely broad view of the claims that it was really worth just emphasizing that even though some of these decisions are based on food and products and brands, companies in other industries really need to be looking at the green guides, looking at these decisions and finding some instructions there as well. Does that sound
Absolutely.
right?
Yeah, absolutely. I guess the other example, and I think relates to utility again,
Right.
that a court saying that sort of this utility had marketed itself as the nation's greenest utility, and who knows what that really means. But the court said there that sort of general subjective unverifiable claims are just mere puffery, and sort of allowed the motion to dismiss to proceed on that basis, and a state appellate court affirmed the decision. So
That's impressive, because I would counsel against that if that was our client.
certainly, yes, very, very risky. But I think that the issue here, particularly where we have cases getting booted from federal court to state court because of the amount in controversy requirement, is that we're having now to build the law from a patchwork of different state courts. And so what does that mean in terms of predictability, right? And perhaps in some months we'll maybe have a better body of federal law developed on these areas.
Whether we like it or not, we
Right,
probably will.
exactly.
That's for sure. But you mentioned the FTC Green Guide. So explain for those that aren't familiar with them, what they're about and why this 2023 is probably a big year to keep your eye on those.
Sure. So the FTC is the federal agency sort of tasked with the oversight of the marketing and advertising of products. And so in 1992, pursuant to Section 5 of the Federal Trade Commission Act, the FTC issued what later became known as the Green Guides. And so the Green Guides are the FTC's interpretive guidance intended to help companies and consumers as well understand how their environmental benefit claims are sort of perceived in the marketplace. And so for each specific claim covered, the Green Guides explain how a reasonable consumer would interpret the claim and provide some basic elements necessary to substantiate a claim and present alternative qualifications that may be considered non-deceptive. And so although the Green Guides are not law or regulation, the FTC does have the ability to bring or initiate enforcement proceedings against violators of them, and can provide an administrative hearing to do so. Violators can face fines. We've seen, I think it was last year, we had some of the biggest fines ever issued by the FTC. But since 2012, I think we've had close to about 40 enforcement actions. And so the issue here is that the Green Guides were last updated in 2012, which is quite some time ago, particularly in this space where we have better science, and we've had an uptick in lawsuits with consumers, I think, really demanding more accountability and more transparency. And the Green Guides have not sort of kept pace with that. So last year, end of last year, the FTC issued a notice of its intention to revise the guides the FTC currently is seeking comment on 19 general issues sort of related to the efficacy of the guides, their use, wanting feedback on the difficulty or burden with compliance. They've also mentioned the possibility of initiating a rulemaking to give the guides the force of law, and the rulemaking would there allow the FTC to report cases to DOJ for prosecution. The meatier and sort of sexier portion of the notice seeks comment on 12 specific claims, which include sort of the hot button areas where we're seeing a lot of litigation. So on things like recyclability, sustainability, the derivative claims like carbon zero net zero, carbon neutral, low carbon, or carbon negative. And if the FTC issues the rulemaking, we'll see obviously plaintiffs have now a civil cause of action, and it will, undoubtedly, even if the FTC doesn't issue the rulemaking, the guide certainly will still remain as the leading sort of interpretive guidance on greenwashing from a federal perspective. Unpredictable,
when those come
but
out, in-house lawyers, not only do they need to read and memorize them, but they need to share them with their sustainability team, their comms team, their ESG folks, anyone that is drafting or putting out any kind of forward-facing information, because that, with the mandates of the SEC compiled with the guidance of the FTC, trying to integrate the two is going to be a challenge. And I think there's going to be a lot of so-called experts on that, but really just reading them and understanding them is probably going to be the best thing. So, but I don't know, what do you predict? Maybe the end of the year on that, even to get a first draft? Because the comment period was extended, I think.
Yes, so the comment period was recently extended to April 24th. I'm actually predicting that the courts are going to move faster in this area. I think that typically it takes about 2 years from comment to actually having new guides.
You mean the FTC? I think you said the courts. The FTC is going to move quicker here.
I'm actually thinking that the courts will, because we have so many cases that are pending and
okay.
are further along. I think we're going to
Gotcha.
get some more decisions that
Yes.
are going to sort of inform where the law is moving. I think the FTC could take potentially about 2 years to issue revised guidance, which is a long time, particularly in this space when we see how quickly things are moving and shifting, even on a day-to-day basis. I also think that aside from sort of the SEC, FTC regulatory action, you also have to look at what the states are doing. And so there have been a number of states that have passed state laws that directly, expressly state that a violation of the federal green guides or marketing your product in nonconformity with them is a violation of the state's Consumer Protection Act. And so California did this, Maine did this. And so you have to really look in several places to make sure that you're conforming with the laws, which is why, hence my recommendation, you consult a lawyer to make sure your ducks in a row before you take action.
Yeah, stacking things up and starting at the state level is hard, especially when you're likely a global corporation operating in potentially a number of states, but maybe distributing products in others, and it gets to be a complex framework. So before we wind up today, time always goes so fast on these. What would you say are maybe the top 2 things you're waiting to play out in this greenwashing space as we ride this ESG wave?
Yeah, so one thing I'm particularly interested is obviously the IRA, and so we're now getting a lot of guidance on the Inflation Reduction Act. I refer to it as the IRA. We're getting a lot of guidance on sort of how those federal monies are going to be deployed, and so a big part of that spending is going to be allocated for clean energy, and we see that industries that traditionally use fossil fuels are going to have to make that shift. And there's going to be an increased demand for things like critical minerals as part of that transition. And so the question becomes sort of, how do those traditional fossil fuel companies go green? And I think as we see more money for projects and project development, I think there's going to be a rash of new litigation in that sector as companies are sort of competing for those federal dollars and wanting to market and advertise their products or services as green. The second thing that I think is particularly interesting, and I'm looking forward to the development of is case law on the intersection of environmental justice and greenwashing. Greenwashing for me is both the E, S, and G and ESG. And so that means your ESG should be intersectional and should include environmental justice considerations. And so again, as more federal monies are deployed to EJ communities and projects begin to develop, I think we're going to start to see more lawsuits where communities or indigenous populations are alleging that a product perhaps was marketed in a way that was misleading, or a project has EJ concerns because it affects livelihood or communities' historic enjoyment, for example, of a river or some other area. And so I'm expecting to see more case law that sort of combines greenwashing, environmental justice considerations, and nuisance claims as well.
Yeah, that is going to be intersectionality. So one way to look at that, it is that I think, as you and I have talked about, environmental justice is a very complex area in and of itself. And when you weave these all together, it really becomes essential to be strategic, thoughtful, and intentional in all that you're doing. You know, all of our clients and companies are doing here in this space. So thank you so much for your incredible insights. I feel like I learned a lot about greenwashing, and, you know, we've come a long way since the Save the Tall movement. That is for sure.
Yeah.
And we're certainly not going to Vegas to bet when the SEC or the FTC is going to get their final rulings out. But so more to come. We'll have a part 2 when there's some additional information and have Tanya back. But thank you for listening to the Environmental Laws podcast with Thompson Hine. I hope that you have found the information shared during today's program valuable. We welcome your questions about today's topic, as well as your suggestions for future programs. You can email me at heidi.friedman@thompsonhine.com. If you would like to learn more about Thompson Hine's environmental group, please visit our website at thompsonhine.com. With approximately 400 lawyers in 8 offices, Thompson Hine is a full-service business law firm recognized for innovation and client service. Our Smart Path approach provides clients with services that are predictable, efficient, and aligned with their short and long-term strategic goals. This podcast is for informational purposes only, provides general information and not legal advice or opinions regarding specific facts. You may not edit, modify, or redistribute this podcast without permission. Thank you, and have a great day.